When someone dies, the family may be left wondering what needs to be done and when to settle the family member's estate, pay the bills, and distribute the assets. Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia. And in today's video, I'll provide you with an overview of the probate process in Georgia. So once a loved one dies and we turn attention to settling his or her estate, the first step is to determine whether the decedent had a will and locate that. The will, of course, will then be reviewed to determine who he or she chose to be the executor, the person to be in charge of managing the estate, and to get an overview of the plan of distribution once the decedent's creditors are paid. If the decedent did not have a will, we still move forward in the same way, but it will be very helpful if the family members, the heirs, will agree as to who should be appointed as the administrator of the estate. From there, we want to evaluate the decedent's estate, determine what assets the decedent had that may need to be transferred through the probate process. Know that not all of a person's assets go through probate. And for a basic understanding of what non-probate assets are, check out our video and blog on that topic at peachstatewills.com and on our YouTube channel. Once we have a good understanding of what probate assets there are, if any, we make a determination as to whether there needs to be a probate estate opened. In some cases, there may not need to be a probate estate opened because there's simply no probate assets to pass through that process. In those situations, if the decedent had a will, that will should be filed with the probate court, but it's filed for information purposes only and not filed to open a probate estate. If, on the other hand, a probate estate is needed to be opened, the next step is to petition to have the probate court appoint a personal representative over the estate. This is somebody who will be the executor of an estate where the decedent had a will or the administrator of an intestate estate. The petition for appointment provides the court with an overview of the decedent's situation, a list of beneficiaries and heirs, and where possible, the consent of the beneficiaries and heirs for the executor or the administrator to be appointed, as well as to agree to certain steps to streamline the process. After completing this appointment process, the court then vests legal authority in someone to be able to manage the estate. Now, the appointment process, as I alluded to, is much easier when the heirs and or the beneficiaries agree to admit the will to probate if there is a will, if they don't contest the appointment of the representative over the estate, and if they'll also agree to waive certain requirements under Georgia law, such as the filing of an inventory and appraisals and annual returns, and a requirement to post a bond for the administrator or the executor. Some of those may be waived in the will, but if they're not, or if there wasn't a will, the family, the decedent's heirs and beneficiaries can agree to waive certain of those requirements to make the process easier, faster, and cheaper. So that's the first step in the probate process, getting through this appointment phase and getting somebody appointed to manage the estate. But once that petition is filed and a representative appointed, of course, the case is not over and done yet. At a very high level, what comes next is the administration phase. This is where the representative is going to marshal together the assets of the decedents, determine what debts and bills he or she owed, and then make some important decisions about how those are going to be paid and how other assets are going to be distributed to the beneficiaries under a will or to the heirs at law. There may be important decisions to make about, do we sell certain property? Do we need to sell real estate, vehicles, other assets to be able to pay the bills or to make certain distributions that may be required? Those decisions are made during this administration phase. And then once creditors are paid and it's time to distribute the rest of the assets, we move to that last phase of distributing assets and closing the estate, which involves just that, distributing the remaining assets according to the will, or according to Georgia's laws of intestate succession in cases where there wasn't a will. And then we close the estate and have the administrator or the executor discharged from office. That's a very high-level overview of the probate process in Georgia. There's lots of little steps that go along the way, and you may choose to have a lawyer help you through this process if you're trying to settle the estate of a loved one. For more information on probate or for help with your case, you're welcome to give us a call at 678-344-5342. You can also find more information online at peachstatewills.com. Thanks.